morning.
Good morning, Your Honor.
Very good. And then we're ready to proceed. And when Mr. Shannon proceeds with his argument, I'm going to ask you this time to mute your microphone, okay? Excellent. So with that, Mr. Shannon, you have 20 minutes, and whenever you're ready, please proceed.
Thank you, Your Honors. May it please the court. My name is Nick Shanine, and I represent the appellant in this matter, Lord and Company. I would like to reserve 5 minutes of my time for rebuttal.
Very good, sir.
This is an interesting coverage case where there's a few different twists, one of which is that the insured, my client, is itself an insurance-related entity. But that doesn't change the fact that when it's still an insured, in this case, for an errors and omissions policy, it retains the protections that are given to all insureds, and that's to have its policies administered fairly. And when being reviewed, for a defense to be given based solely upon the contents of the complaint that's been raised against it. Indemnity is a different story. Indemnity utilizes actual facts, but in this instance, we didn't get to reach the indemnity question because the lower court elected to remove the case from further consideration based purely upon the duty to defend not existing in this case, which was error for a number of reasons. The most important of which is that it was violative of what we've called throughout the briefing as the 8-corner rule.
If I miss, and I apologize for butchering your name, Mr. Shanine, I think I'll to Shannon. Mr. Shanine.
All my life, Your Honor, it's just fine.
All right. Very good, sir. And let me see if I could kind of streamline and to see if I could understand your position. I recognize, and in your brief, you do set forth about the 8 corners, but in this case, the posture of this case is summary judgment, correct?
That is correct, Your Honor.
All right, so we're not in a motion to dismiss aspects. So given the fact of the posture being summary judgment, in this case, as I understand the judge's ruling, the judge granted summary judgment on the basis of the exclusions that were within the policy. Is that correct?
That is correct, Your Honor.
All right, and my understanding is also procedural-wise that at one point your client did receive, there was some duty to defend at the beginning, but then later on the insurance company, when they recognized the exclusion applied, that's when they end up withdrawing. Is that correct?
That is correct. What makes that interesting is that Lloyd's did start a defense and then within that year pulled its defense. The exclusion that they pulled it on was not the exclusion that the judge primarily relied upon. The judge below did use 2 findings. He went with what he considered a primary basis and then a secondary basis. The secondary basis is what Your Honor was referring to, and that was the insured versus insured exclusion, but the thing, and I'll definitely get to that, but it's important to understand that the duty to defend was not pulled at that time for the reason that they have now escaped all liability on its summary judgment, and that is the prior knowledge exclusion. And if I could, Your Honor, I'd like to clarify that it's absolutely true. We all understand motions to dismiss are contained to the 4 corners of the complaint as alleged. We accept all the facts as true and all the reasonable inferences thereon. That is the golden standard for motions to dismiss. Summary judgment is different in that summary judgment, obviously, you're allowed to look at documents that are outside of the 4 corners of the complaint. But that's not the standard for duty to defend analysis. The duty to defend, and this court went through a detailed analysis of duty to defend versus duty to insure, duty to indemnify in its recent Alicia Enterprises versus Nationwide case from 2018. And in it, it explained that the duty to defend is much broader than the duty to indemnify. And the duty to defend.
Would you agree with me? And I agree with you on that, Mr. Shanine, but
Sure.
Would you agree with me that despite the broad duty to defend standard and the summary judgment posture in this case, that if the undisputed facts show that there's absolutely no possibility of coverage, then summary judgment, then there's no duty to defend at that point. Would you agree with that?
I would, if those facts are applicable to the circumstance and are something the court's allowed to review. And what your honor's getting to is that there, I believe, is that the standard was set forth by the Florida Supreme Court in Higgins. In that case, it gives the analysis that, look, we're all clear on this. Duty to defend is this 4-corner or 8-corner analysis. When we talk about 8 corners, we're talking about the 4 corners of the complaint and the 4 corners of the policy, hence 8. But they did drop a footnote that said, there could be an exception. There could be a time when other facts come into play that would not normally be in a complaint that could otherwise avoid coverage. And it's that exception that the insurer is now trying to become the rule. They would like to run everything through the exception, and the exception is exquisitely rare in its application. But interestingly, the appellee had cited a case that comes from the Middle District of Florida, and a fair number of cases that we have to rely on are federal in nature and not state, because these types of claims are often brought in federal court. And even there, we found, interestingly, in this particular case, that the second of the issues still doesn't have any real case law to really guide us, that we're all in kind of a novel circumstance. And that's, of course, great for bringing to a court like this to have some edification placed upon the practitioners and the insurance companies, so they know what the rules of the road are. But getting back to the Amerisure case, that court went through that same analysis and recognized that Higgins was the rule, that Higgins had an exception, and that exception was rare. And it explained that exception would only apply when there was unalleged facts that were undisputable and that would unambiguously defeat coverage. So I think that that's a reasonable platform. If we're going to deviate from the 4-corner or 8-corner analysis, and we're willing to look outside of the policy, and that policy is the gold standard by which we measure whether or not a duty to defend exists. If we're going to break outside of it and start to look at these extraneous facts, we need to make sure that those extraneous facts are undisputed and unambiguously defeat coverage. And it's our position that neither of those 2 factors exist in this case. With regard to prior knowledge, the court basically had the testimony of Mrs. Schwartz versus what the court believed that the beliefs and knowledge of Mrs. Schwartz should have been. That Mrs. Schwartz was consistent throughout her deposition that she did not have a belief that, based upon the circumstances on the ground at the time as these events were unfolding, that there was going to be a claim that could be raised against her and her company.
But counsel, isn't the nature of the inquiry about prior knowledge, I mean, doesn't that just almost have to have some objective, reasonable component to it? Because otherwise, the defense of the what the insured is always going to say is going to be a stick your hand in the sand kind of defense. Here, I mean, you've got, goodness, you've got an email where she says, I'm a terrible agent, I couldn't even get this covered right. You've got a fair amount of evidence that certainly, I mean, her husband is on the other side of this claim. You've got a lot of evidence that arguably suggests, and I'm trying to put that kindly, arguably suggests that, yeah, she knew it. She knew she had a claim on her hands. What do you do with that under the standard that you are articulating now? Because you're telling me, well, it's what was going on in her head, and my suggestion is now maybe there needs to be an objective component to that.
And I'm not going to disagree, Your Honor, that if someone flat out denies the sky is not blue, it's green, we're allowed to say we know the sky is blue. The difference here is that it's a professional call made by an agent or someone who handles insurance on the ground, because she sees these all day, every day, she has her professional knowledge that lets her say, this doesn't trigger my radar.
Well, but
This-
wait a minute. I mean, if okay, so I hear what you're saying. You're kind of layering in, well, there's a professional standard, and let's just go by what the professional would say. She got an attorney's demand letter. I'm going to sue about this. I mean, what else do you do with that? But oh, it looks like we got a claim on our hands.
And of course, there were the circumstances on the ground at that particular point were still
Right.
fuzzy, and we've
Right.
we've got the Hall machine company saying, well, disregard that letter. We didn't tell our attorneys to send it. And when you have this kind of circumstance, you know, we're not, in my belief, indisputable and unambiguous. And it goes back to law school in my mind, where on summary judgment, we're taught that you have 99 nuns on the bus and you've got the one drunk guy outside the bus. And the 99 nuns testify one way, the drunk guy testifies the other. Summary judgment, you gotta say there's a question of fact, and you gotta let that go through.
And if I may, Mr. Shaneen,
Sure.
to follow up with what Judge Lucas has said, I think you're taking the position that there has to be an actual lawsuit or knowledge of an actual lawsuit. Isn't it really not necessarily that way, but any knowledge of any underlying facts that could give rise to a lawsuit? And that's when she should have alerted. And so that goes back to, I guess, to follow up what Judge Lucas was saying, is that I think you're taking the position, to follow up, is subjective versus objective. The fact that she was given that letter, it could, and then even though she got information later on, avoided, it could still have that. And as it turned out to be, it did ultimately happen.
Yeah, and Your Honor, I would say to that it is, again, we can't allow the exception to swallow the rule. That insurance companies can always go back to some, you know, Paul's graph foreseeability sort of analysis and say that, but for this one event that happened in the 18th century, this would have never happened. You just can't defeat coverage that easily. At least as much. Again, we're not talking about indemnity coverage. We're not talking about the actual facts as you find them on the ground. That's what we do for a duty to indemnify. But for duty to defense, we're supposed to be constrained to the four corners of the policy and the four corners of the complaint. And so when we allow these extraneous facts to come in under this exception under Higgins, we can't then look at that expansively. If
Mr.
you're going to
Shaneen,
win on
I think what you're bumping up against here, and it may be very well be an immovable object, is that you have a pronouncement of a legal rule that suggests unbending and unerring boundaries, the eight corners that you can't look, and then an exception that got dropped in a footnote that turns out to be one that at least in terms of what the footnote suggests, is one that could be very variable. I mean, there could be a whole host of things that you could wedge into that silo, as they would not naturally allege that in a complaint, but it would defeat coverage. I think that's what you're bumping up against, and I don't know what to do with that.
I'm not going to disagree, Your Honor. I'm just hoping that the forward momentum of allowing a litigant to proceed past summary judgment is the irresistible force to overcome that unmovable object.
Well done.
Thank you, sir. These at-home Zooms aren't bad. Yes, Your Honor.
Because you have almost 2 minutes left before your rebuttal. I want you to touch upon the insured versus insured exclusion real brief.
And so the insured versus insured exclusion, that was the one I was referencing earlier, where we're essentially in a novel area that Appellee cited one case, appellant cited one case, because those were the only cases either of us could really find on this issue, that it just doesn't come up often. And so the question really becomes, there's actually three questions. First question goes back to the ultimate question. Are you even allowed to get to this question, because it's still outside of the four corners of the policy and the complaint? But assuming you do, then the next question is a hyper-technical directorship where someone never exercises that directorship, never does anything on behalf of the other company. It's in name only as a estate planning tool. If that technical directorship is allowed to equate to a get out of coverage card free for the insurer, that's an open question. The other open question is the date that it was filed the complaint was before we ever had the co-directorship technical estate planning issue come up. So when we cited the case of Rigby versus Underwriter from the third DC in 2005, the line that I think is critical from that case, and I'm going to end here and reserve the rest of my time for rebuttal, is that the insured in that case was found that they did not bring the adversary action while acting as an officer or director of the other company. And that's our case here. While there may have later, after the complaint was filed, been this, this thing that should have been done instead by powers of attorney instead of by drafting up directorship papers and then sealing them, that instead, that was not the case at all. At the time it was filed, they did not bring that action as acting as an officer director. And I think that ruling should be dispositive for this issue. And I'll reserve the rest of my time for rebuttal. Thank you, Your Honors.
All right, just to let know, Mr. Shinny, you have about 4 minutes for rebuttal, okay? Very good, sir. All right. Okay, Ms. Stein?
May it please the court. Dinah Stein on behalf of Applee, certain underwriters at Lloyd's. This is perhaps interesting facts that still come down to very basic and uninteresting insurance principles and undisputed facts showing, number one, as far as the prior knowledge exclusion, that at the time Ms. Schmaltz applied for insurance, the coverage at issue in 2005, she knew that her client, the insured, had been denied coverage based on improper notice, which she had been put in charge of. And she knew that she had contacted this client because of the carrier, because she had contacts there, and asked it to reconsider. It was confused. And at that point in October of 2002, she sent the email saying, I'm really having a hard time with this mess. I must suck as an agent if I can't even procure coverage for my husband's engineering firm. And what kind of E&O claims will I get when you're denying legitimate claims? So these facts are undisputed. She knew at the time when she applied of this situation. She also knew that since then, the Halls, the underlying claimants, had sued her client, and the carrier, American Safety, had again denied coverage based on, among other things, improper notice and failure to procure the proper coverage. So these are undisputed facts. There's nothing else that a jury can come up with. And in fact, that both sides moved for summary judgment below, saying that the court can make a legal call on these issues. Now, the coverage as far as, and what the plaintiffs, the insured wants the court to do and wanted the lower court to do is say, ignore these facts. You can't look at them. It's a duty to defend. They're always going to stay out of the court's consideration, and they're always going to go to a jury. And Lord ignores a very long-standing, it's not just a footnote exception to the Eight Corners rule. It is a very long-standing line of cases which has been applied prior to the Higgins decision and since the Higgins decision, acknowledging this rule. And significantly, Higgins even identified as a natural exception to the Eight Corners rule, notice problems when you don't comply with the duty to cooperate and place a carrier on notice. The Diamond State versus Boys Home case that both sides have discussed specifically recognized that a prior knowledge exclusion would almost always fall within the Eight Corners rule, unless there's something in the complaint taking it out of that. It's going to generally be an issue that can be considered by the trial court. So the trial court here didn't have a fact issue. He applied the mixed, as the court pointed out, the subjective and objective test. And he disregarded Mrs. Schmaltz's own discussion that she thought her husband would never sue her and that she didn't realize this would turn into a claim. He properly went to the law, which says you look to whether just the facts, the underlying facts, would reasonably place somebody on notice of a potential claim. It's no different than there's a case that was cited called Fidelity versus Houston, where the insured said, yeah, I was aware of the facts, but this particular entity never sued people. So I really didn't expect that I'd be sued. And the court said, that's not the test. It's not what you thought. It's what a reasonable person should have thought.
But
So
that kind of inquiry, doesn't it seem more properly suited towards almost like a credibility analysis, which would require live testimony, require the trial judge to size up what everybody's saying, to size up Ms. Schmaltz's, size up what what the documents are and how the witnesses react to them, whether or not her basis for concluding that there was no claim there was objectively reasonable. Isn't that something that maybe shouldn't be decided at summary judgment?
Judge Lucas, if the only issue was subjective, the first part of the test, which is the subjective, what they knew, I would say yes. But the test has been repeatedly acknowledged in the courts that it's not just subjective. It's not what they knew. If it was that, this is a claim between married people. No one's ever going to think she knew, or maybe they would. I mean, that's why you have this objective portion. Right. To take these issues out and look to see what a reasonable person sitting in her place would understand. And these aren't disputed facts. These are undisputed facts as to her email.
So I think what you're saying, if I understand your argument correctly, is that the weighing of credibility might come into play on the subjective part of the analysis, but the objective part, look, the facts are what the facts are. This, here's the demand letter, here's the testimony, take it in the light most favorable to the non-moving party if you want. The facts don't change, and an objectively reasonable insurance agent would have realized they had a claim on their hands.
Absolutely.
Am I understanding that correctly?
And it's that simple. And I point out that plaintiffs, the insured appellant, in their brief, they don't take issue with this, or at least in the initial brief, as this just being a big fact issue that should have been decided by a jury. It was their main thrust of the argument was this is an 8 corners rule, and you can't go beyond that. And alternatively, you can't base things on speculation. But remember, both sides moved for summary judgment on this. So there was no issue as to what the facts were. The facts were she emailed the carrier in 2002 and said, I'm really having a hard time with this mess. I must suck as an agent. So she knew of this claim. And so that is correct. This isn't something that has to be weighed by a jury when the evidence is undisputed that she knew at the time of the act. And that's all she has to know for the objective portion of the test. And I'll just say, just to point out something, and I'm not sure that how pertinent this is, but the court did find, and I'm just looking at the court's amended order on summary judgment, he found that Lloyd's was well within its right under both the prior knowledge requirement of the policy and exclusion and to deny defense and indemnity. So he did find as to the defense and coverage, and plaintiff has taken issue only with the duty to defend because they want to try to get around, use the 8 corners rule and try to have the court not even consider this. So I think plaintiff has perhaps implicitly acknowledged the difficulties in this case of getting around her email saying, I must suck as an agent. I'm really having a hard time with this and knowing of the claim. And the court was absolutely correct. He looked at all of the evidence that was before the court. Again, it was undisputed and determined that under the objective test, she knew of the possibility of the claim, which is very broadly worded, both in the policy as not only an exception, but as a coverage provision. So this policy doesn't even provide coverage to anyone who knew of an act that could have given rise to a claim. Now, the court, of course, had a alternative and additional basis for granting summary judgment in favor of Lloyd's and denying summary judgment that was filed by the insured. And that is, of course, the insured versus insured exclusion. And I'll say that the court took issue at the hearing with plaintiff's attempt to sort of bypass or not take seriously, this I'm a director in name only argument. What he said was, well, these statutes say what they say and they mean something. When you become a director, there are liabilities that come with that. And he's correct. The statutes don't have provisions for, directors in name only or officers in name only. They have a meaning under the law. And he said, maybe I put a little more formality to these statutes than the Schmaltzes do. Now that we actually cited as to that 3 cases applying the insured versus insured exclusion, two of them from federal court and the First District Court of Appeal, which frankly apply these exclusions strictly. They look beyond, and they've said, in fact, the 11th Circuit, Judge Toflat said, we're not looking to the reason for the exclusion, which is frankly to avoid collusion, which, I could have a little bit of that inference here, but it's not a husband versus wife exclusion. But they said we strictly interpret these exclusions. And if there's a director and there's an insured versus insured exclusion, it's going to fall in it, and we're not looking past the plain language of the exclusion. Now, that there was the other issue. So the court rejected this in name only argument that the plaintiffs had below. The plaintiffs also argued, as Mr. Shanine argued today, that you only look to the point of time when the carriers first put on notice of the claim. Can't look beyond that. And there's absolutely no law supporting that argument that if an insurance company finally gets notice of a complaint and finds out that at the time the plaintiff is actually a director or was a director of the insured, they're saying you can't do anything about that. You have to go back in time to when the carrier is first notified. As counsel for Lloyd's explained below, claims aren't a point in time. They start when a company is first put on notice, and they continue. And it wasn't until that Lord was sued that Lloyd's had a duty to defend and was able to look at this exclusion and invoke it. So there's absolutely no support for this point in time argument that the plaintiff made below and is making today. So clearly, this is a case of undisputed facts. We don't have to weigh testimony. We don't have to speculate as to what happened. We know it from emails. We know it from letters. We know it from the undisputed evidence. Both sides moved for summary judgment. There's no issue of fact that has to be decided here. And again, the plaintiffs only took issue with duty to defend when the court, in fact, found there was a duty to indemnify. And that's because the court was well within its discretion and, in fact, duties and weighing and looking at the facts. There was nothing to weigh, and summary judgment was properly granted. So we would submit that this summary judgment be affirmed for the reasons set forth below. Thank you, Your Honors.
Thank you, Mr. Tyne. All right, Mr. Shanine, you've got your 4 minutes, sir, for rebuttal.
Thank you, Your Honors. I appreciate it. I'll start with where it ended, talking about the insured versus insured. Ms. Stein appropriately notes that there were more cases discussed. What I was meaning for the novel issue before this court is that there's only one state court case that either party could find for each side. And we believe that when looking at those cases, the Rigby versus Underwriters, case was a more appropriate case to analyze for purposes of applying to this case. There was no hint of collusion, no collusion, if you will, that was indicated anywhere on the record below between these two individuals. Yes, they're husband and wife, but they also explained throughout their testimony that they kept an arm's length relationship on all such business matters, and on purpose, because many of Mrs. Schmaltz's best clients were his competitors. So the last thing she wanted was to provide any sort of visual indicia of connexity between them for purposes of the companies. So,
but Mr. Shanine, even if there's no hint of collusion, your test on this point seems to me rather hard to apply across the board.
Well, if the test is the three factors that I was discussing, that you've got to look at the four corners, but if you're not inside the four corners, you got to look at the timing on this particular thing, and the timing is important. Even if she's correct, there's no law in Florida that said you look only at the time. There's no law that says you don't. And I think if this court looks back to the Barron Oil precedent from 1985, that's canon in this field. Barron talks about, you look at the policy, you look at the complaint as it was on the date that it was filed. Barron talked about, look, we don't care what subsequent amendments did. Your duty to defend starts now, starts the day that policy is filed. So the date the complaint is filed. So I do believe that there is rational reason why you look at the date the complaint was filed is the date you look at whether or not your officers, because otherwise insurance companies could wait, litigation could go 10 years and then somebody's cousin becomes on someone's board of directors and bam, the insurance company can now break out an exclusion after 10 years. Here we're closer in time, but it's the critical part is the time itself. So we do believe that that's the issue. As to the primary case, we would also indicate that the boys' home case makes clear that you are to look at professional obligations expansively. That case, when you look at it, did not find that there was a duty to defend exclusion that was appropriate. Even though the court was willing to look at it, it said we're not at that stage. Summary judgment is not that stage. What Judge Lucas asked was appropriate for, wouldn't this matter be a matter that would best be resolved by a trier of fact as a fact issue? And the answer to that question is yes. And because it's a yes, because there are ambiguities that exist, this case should have proceeded past summary judgment, and Lord and Company respectfully request this court to reverse and remand to allow these companies to get their day in court. Thank you, Your Honors.
Thank you, Mr. Shanine. Thank you, Ms. Stein. You outdid well for the virtual oral argument. All right, thank you. So at this time, I think I'm going to ask you to get off, and then it's going to take a little bit of a lull by the time we get the others as well. Thank you both.